Good day to Dr. RADHUAN. My name is Sean Victor Terence Lim, matrix number 2023-168791, and today our group will be presenting our draft agreement. This presentation will cover the introduction, the purpose of the agreement, ownership structure, corporate governance, protection of shareholders, resolving disputes, corporate compliance with the Contract Act and compliance with the Companies Act, and an overall conclusion to summarize the entire document. Now, let's look at the purpose of the agreement. As established under our recitals and clause 2, the primary purpose of this agreement is to regulate interrelationship inter se between the shareholders in the spirit of mutual cooperation and the distinct strict operational boundaries of the company itself to align with modern economic trends, and the parties have explicitly restricted the core business to advancing warehouses, e-commerce operational, and IT solutions within Malaysia. By cementing this purpose in writing, we provide an absolute commercial certainty and protect the company from unauthorized high-risk operational shift by management. Now, let's jump into the introduction. This document is titled Shareholders Agreement of Markonas Adrian Berhad Company number 2024-2608-1009. Legally brought into existence on the 5th of July 2016, it is executed by four distinctive individual shareholders: Haikal Danish, Irene Adriana, Shafiq Kyle, and Faisal Arifin, alongside the company itself, while drafting the execution by our firm MUSTAFFA and Victors and Partners. Looking at the share capital distribution, our draft establishes a mixed capital structure totaling of 800,000 ringgit, divided into 800,000 ordinary shares, starting at RM1 ringgit each. We have intentionally customized this distribution to reflect various levels of financial experts and voting power among the parties, such as Haikal Danish holding 50% controlling majority with 400,000 ordinary shares, Irene Adriana holding 25,000 stake at 200,000 ordinary shares, and Faisal Arifin holding a 12.5% stake with 100,000 ordinary shares. But for Shafiq Kyle, holding the remaining of 12.5% through 100,000 preference share, from a drafting perspective, it is a crucial distinction. As a preference shareholder, Shafiq yields priority over capital returns and dividend distribution, but does not possess voting rights and ordinary corporate resolution. Now, let's look at the dividing policy. Under clause 14, we have drafted a clear, transparent policy to manage investors' expectation, subject to availability of the distributable profits and passing the statutory solvency test under the Company Act 2016. The company targets to distribute at least 30% of its net audited profit after tax in each financial year. This guarantees a predictable return for the minority of passive investors while ensuring the board retains sufficient capital for corporate reserves and working expenditures.
On to the corporate governance and management structure of Markonas Adrian Berhad. As you can see in clause 5.1, the executive authority, supervision and control of the business are fully vested in the board of directors. We put this specific clause because it establishes a clear separation of powers between the daily management executed by the board and the ownership held by the shareholders. This clause ensures that the directors are legally bound to act honestly and in the best interest of the company at all times. Furthermore, we mandated a minimum of 3 directors and an odd number structure on the board as our first operational shield to prevent structural deadlocks or split votes during board meetings. Next, let's examine the operational capacity of the directors. As you can see in clause 5.3, the board is given specific itemized powers, ranging from formulating business strategies and approving annual budgets to executing commercial agreements and entering borrowing arrangements. We put this detailed list of powers because in commercial contracts, certainty is an essential element under the Contracts Act 1950. By drafting these operational boundaries clearly, we eliminate any ambiguity regarding what the management can and cannot do. However, this clause ensures that the board's power is not absolute. Their authority is explicitly subject to the reserved matters under Clause 13, meaning that any transaction exceeding the ordinary course of businesses must return to the shareholders for approval, preventing executive overreach. Now, let's look at how the board is formed and protected. As you can see in Clause 6.1, each shareholder holding not less than 20% of the issued ordinary shares has the absolute right to nominate and appoint one director to the board. We put this specific clause because it protects the equity voice and representation of substantial investors. Based on the share capital table we drafted earlier, this means both Haikal Danish and Adriana instantly command the right to secure the seats on the board. Conversely, Clause 6.3 ensures a balance removal mechanism. A director can only be removed from office by the specific shareholder who appointed them, or via an ordinary resolution in compliance with the Companies Act 2016. The structural stability ensures that minority shareholders are not unfairly stripped of their board representation by a majority. Finally, let's address the ultimate protection mechanism, Clause 13, the reserved matters. As you can see in this clause, the company and the directors are strictly prohibited from taking major constitutional or structural actions without obtaining the 100% unanimous written consent of all shareholders. These include crucial matters such as amending the company's constitution, altering our core e-commerce and warehousing business code, winding up the company, or executing financial commitments exceeding 1 million ringgit. We put this specific clause because under Malaysian company law, a simple majority could easily override minority interests. Therefore, this clause ensures that minor equity holders like Faizul Arifin and our passive preference investor, Shafiq Kal, possess an absolute veto right over fundamental changes that alter the commercial foundation they initially agreed on upon under the Contracts Act 1950. It perfectly balances majority control with statutory minority protection.
Now, moving on to the protection of shareholders in our shareholders agreement. Protecting shareholder is one of the main purpose of a shareholders agreement. Shareholders invest their money in the company, so it is important to protect their ownership, their rights, and their interests. Without proper protection, dispute may arise. Minority shareholders may be treated unfairly, or ownership of the company may change without the agreement of the existing shareholders. To avoid this problem, first is the pre-emptive right clause. Under our agreement, before any new shares are offered to outsiders, the company must first offer those shares to the existing shareholders based on their current shareholding. Likewise, if a shareholder wishes to sell their shares, the remaining shareholders are given the first opportunity to purchase those shares before they are sold to a third party. We included this clause because it prevents the dilution of ownership. For example, if a shareholder currently owns 25% of the company, issuing new shares directly to an outsider could reduce the ownership percentage. By giving existing shareholders the first right to purchase the share, they have the opportunity to maintain their ownership and voting power. The second protection is the restriction on transfer clause. In our agreement, a shareholder cannot freely sell or transfer their shares. Any transfer must first receive approval from the board of directors and must comply with the term of the agreement. We also specifically prohibit transfer to direct competitors, bankrupt individuals, or any person who refuses to be bound by the shareholders agreement. We included this clause because shareholders in private companies usually choose their business partner carefully. Allowing anyone to become a shareholder without restriction could expose the company to unnecessary risk. For example, if share were transferred to one of the company's competitors, confidential business information could be exposed and the company could be affected. The third protection is the tag-along right clause. Under our agreement, if the majority shareholder decided to sell more than 50% of the company share to a third-party buyer, the minority shareholder have the right to join the sale. This means the buyer must also purchase the minority shareholder shares on the same term and condition. We included this clause to ensure fairness. Without this protection, majority shareholders could sell their shares and leave the minority shareholder with a new controlling owner whom they did not choose. The minority shareholder might also receive a lower value for their shares in the future. The final protection is the drag-along right clause. Unlike the tag-along right clause, this clause protects the overall interest of the company and facilitate a successful business sale. Under our agreement, if a shareholder holding at least 70% of the ordinary shares agree to sell the entire company to a genuine buyer, they may require the remaining shareholders to sell their shares as well. We included this clause because in some situation, a buyer only wants to purchase the company if they can acquire 100% ownership. If a small minority shareholder refuses to sell, the entire transaction could fail. The drag along right prevent one or two minority shareholders from blocking a business opportunity that benefit the company and the majority of the shareholders. At the same time, our agreement also protect the minority shareholders because they must receive the same price per share, the same payment method, and the equal treatment as the majority shareholders. Therefore, this clause balance the interests of both majority and minority shareholders.
Okay, so next, moving on to the resolution clause, where this clause provides a mechanism for resolving a deadlock between shareholders. A deadlock occurs when the shareholders or directors are unable to reach a decision on important matters affecting the management or commercial operation of the company, or where a shareholder deliberately prevents a quorum by failing to attend meetings. So basically, we included this clause because the shareholders' agreement should not only regulate how decisions are made, but also provide a solution when decision cannot be made. Without a deadlock mechanism, the company may become unable to operate effectively. So basically, this clause adopts a three-stage approach. First, the shareholders must attempt to resolve the dispute through good faith negotiation within 14 days. If negotiation fails, the dispute proceeds to mediation by a mutually agreed mediator or one appointed by the Malaysian International Arbitration Centre. If mediation is unsuccessful, the agreement provides a buyout mechanism, allowing one shareholder to buy or sell shares so that the deadlock is brought to an end and the company can continue operating. So basically, the buyout mechanism prevents the company from remaining indefinitely deadlocked. Rather than dissolving the company, one shareholder exits the business while the other continues the company's operation. So basically, overall, this clause ensures that business continuity by providing a structured and progressive mechanism to resolve shareholder disputes through negotiation, mediation, and if necessary, a buyout, thereby avoiding prolonged deadlock and protecting both the company and the shareholders. So does our agreement fulfills the main ingredients of a valid binding contract under the Contract Act? Yes. In drafting the shareholders agreement, we ensure that it satisfies the essential elements of a valid contract. First, the offer and acceptance. The agreement is formed when all shareholders agree to its term and execute the agreement. Next, the consideration. Each shareholder promises to do something, for example, they comply with the confidentiality and transfer restriction, respect preemption rights, and also participate in the management. These mutual promises are considered as a valuable consideration. Next, capacity. Each shareholder must have legal capacity to enter into a binding agreement. Since all the shareholders provide their IC, therefore it can be concluded that all the shareholders does have the legal capacity. Next, certainty. The agreement clearly defines the rights, obligation, and procedures relating to management, transfer of shares, and dispute resolution, ensuring certainty of contractual terms. And lastly, the intention. The agreement is reduced into writing and executed by all shareholders, demonstrating the intention to create legal relation. And next, does it comply with Companies Act? Yes, in drafting this agreement, we ensure that its provisions are consistent with the Companies Act 2016. The Act provides the statutory framework governing the companies in Malaysia, while the shareholders agreement supplements that framework by setting out additional contractual rights and obligations agreed upon the shareholders. For example, the management and powers of the board were drafted in line with Section 211, which provides that the business and affairs of a company are managed by or under the direction of the board of directors. The provision on the appointment and removal of directors are also consistent with Section 202, 203, and also 206 of the Companies Act. So overall, the agreement was drafted to complement the Companies Act 2016 by ensuring that the contractual arrangement between the shareholders remain consistent with the statutory requirement governing private companies in Malaysia.
In conclusion, this entire shareholders agreement operates as a comprehensive, self-contained governance mechanism engineered to balance power, minimize operational friction, and protect equity investments within Markona Sdn Bhd. while the introduction, purpose and ownership structure establish the foundational and financial bedrock. The document as a whole builds a highly sophisticated system of corporate checks and balances. It seamlessly bridges the gap between strict statutory requirements of the Companies Act 2016 and the commercial expectation of the parties by integrating robust board management rules, anti-dilution preemptive rights, and balanced tag-along and drag-along exit protections. Furthermore, by safeguarding the companies through a non-competitive governance and establishing a dual-stage deadlock resolution pathway involving mediation and contractual buyouts, the contract successfully minimizes litigation risks, guarantees operational continuity, and establishes an enduring legal framework for Markonas and Berhad to thrive. Thank you very much. That concludes our presentation.